Hello, welcome to our podcast. Here today with Richard.
Hello.
And today we're going to be speaking about the perils of making gifts of land and property. So, to pass on to Richard, can you explain to us what exactly that is?
Yeah, I will. So we come across a lot of situations with clients where they want to make a gift or they have made a gift. And we're talking about specifically with regards to land and property. So we do a lot of property investors, and even just families who, they've got an inheritance tax challenge, or they're considering, how to reduce their inheritance tax situation and they want to give to their children during their lifetime. And it can cause problems. And when we explain to them what the problems are, it's like, okay, so what do we do next? So today's show, I thought we can talk about what problems potentially can be caused, what we got to think about as private wealth advisors, as in my industry, any private wealth advisor or private client advisor, what we think about, so you are more informed of how to make your decision and get the right advice going forward. So one of the things that is a big topic, and I'm going to split it up into two areas, or try. It might be a part two. We'll see how we get on with time. Is gifting of property which you live in, and gifting of property or lands which you may own or rent out. I'm not going to talk about businesses today because that's a whole other kettle of fish. But normally with private residential property, so it could be either where number one, what we currently live in ourselves, and then number two, um, other properties that we either let out or family members are living in, etc. How do we treat it? How do we deal with it? All right. So the first part one, is really the biggest challenge that we find is something called gifts with a reservation of benefit. Yeah. And what that basically means, how I describe a gift with reservation of benefit, is if I've got, my, like, for example, this calculator, and I say it's mine, and I say, Sonia, this is your calculator, and I'll give it to you for you to use. It's totally yours. Do what you want. And every day I'm using the calculator if it's my own. Whose calculator is it really, in essence? Eh? Um, Even though legally it's got Sonia's name in it, I'm using it. So I'm the beneficial owner because I'm constantly using it. And it was originally mine in the first place.
So, being truly, it doesn't technically count as a gift, or
Well,
it's still a gift.
legally, yes, but beneficially, no.
Okay.
Yeah. Maybe I should clarify a bit legal and beneficial ownership. I think that might be something that everyone needs to understand. With lands, well, with any assets that you own, it could be a pen, it could be your shopping from the supermarket, it could be land, right? You have title. The car you drive, anything you purchase, you would have title to it, else you could never own it fully. And I say you have full rights, title, and interest. So you go and buy a car, you fill out a V5 to say who's the register keeper. You go shopping at your local supermarket, or wherever your choice is. You got a receipt. So if the alarm goes off, the first thing I ask you is, where's your receipt? Where's your proof of ownership? Okay, and so same with land. You got on land registry, or you got a deed, something to confirm you own it. Yeah, a mortgage is just a charge on the ownership that you had, and you've exchanged that charge for some money. So you own something. So there's two ways to own. Okay, you can own it fully, which is what most people do. So they have full rights, title, and interest to that thing, that asset. So his calculator, bring it back up here. I have full rights, title, and interest of it. It's mine. I've got the receipts. It's mine. I have full ownership of it. And then I can also make a gift, and that can be gift, absolute gift. So Sonia owns it 100%. It's hers now.
Mhm.
Or I can gift it in a way that, well, let me be the one be responsible for its maintenance and upkeep, and all Sonia has to do is enjoy its use. And so we've divided that ownership into two forms of title now. One is possessory title. I'm the trustee. I'm the one that looks after it, administrates it, pays the bills on it if it's due, and then Sonia just uses it. She just uses the calculator when she needs it, and I make sure the calculator works, the batteries are changed, it's maintained, replaced if necessary. But that's now two titles. Beneficial ownership, Sonia has the use in equity, which has use, and legal ownership is I'm I'm the one responsible for it. So the bills will come to me. Any form of questioning liability will come to me. But because it's not mine, then that's where the protection starts to come in. All right. So 2 ways to own, 2 ways to make gifts.
Sorry to
Mhm.
cut you off. With those 2 ways,
Yeah.
so you know the part where you maintain it,
Yes.
just to phrase my question properly, you know how people usually gift to try and reduce their inheritance tax.
Yeah.
So if that second type of gifting that you mentioned about maintaining,
Yeah.
did do they still have to pay some sort of inheritance tax? Would
Potentially.
that
So the
be
one who's
good?
maintaining.
If you're maintaining the one where you just give it, and then there's the one where you're maintaining it.
So effectively, what you're asking, if a trust is the device that splits that title up,
Yeah.
and so the trustees, from my understanding, potentially could be liable for tax depending on the rules and what's going on.
Mm-hmm.
Potentially,
Okay.
yeah. Not to get too technical, but a body of trustees is a separate legal entity, and so there's a separate legal taxation regime for a body of trustees.
Yeah.
We call it a relevant property trust. Okay, so relevant property has its own tax regime, separate to an individual, separate to a corporation, separate to a partnership. It's just separate tax rules.
Okay, thank you.
Yeah.
Yeah.
So I forgot what I was saying now.
Oh, we do relating to that.
Yeah.
We do also have high rate stamp duty impacts.
I'll come on to that.
Okay.
I'll definitely come on to that.
Okay.
So I think I was talking about. I was preluding. That's it. That's it. Preluding about what a gift is.
Okay.
And beneficial ownership versus legal ownership. So if you have made an absolute gift, which was most people want to do, they want to gift. There's no trust involved right now. It's just an absolute gift. So we're saying I'm going to give it to my child, and they own a percentage of my land, like 20%, 25%. It's theirs. No one else can take it. It's in their name. That's one thing you can definitely do, but we've got to be careful how you make gifts. So there's something called a gift with reservation of benefit. And when I gave the example of giving you the calculator, but I'm still using it, then I'm giving it to you, but I'm reserving the benefit. You're not benefiting. So HMRC says, well, you made a gift, but we're reserving the benefit because in equity, because really you're still using the gifts.
Yeah.
And so there's no inheritance tax privileges when you make gifts and still use it. So when you're living in your house and you've gifted half of it to your son or daughter, the only one that's exempt is I say exempt, for inheritance tax purposes, it may not apply, but when you're giving to your son or your daughter or a third party and you're still living in there yourself, okay, it may be in their name, but it's still part of your estate for inheritance tax purposes. Maybe not for any other like general taxation. And maybe for probate purposes, it's not yours. But for inheritance tax, the benefit has been reserved.
Yeah.
So why should you have your cake and eat it? So you're still going to have an inheritance tax problem on 100% of the assets, even though you might own 80 or 50% or 40%. You're living in the property. You're enjoying the 60% that you gave away. So the benefit's been reserved. So you're going to still endure an inheritance tax on 100% of the asset. And most people are not aware of that. And that's one of the biggest hurdles that we find people will trip up on when considering making a gift of the property where they live in. Okay. So now you mentioned about the stamp duty. Now, most children are first-time buyers, and you are causing them a real problem, which they may not realize because if you put the asset in their name, okay, there's no other taxes because you live in the property, you can claim certain reliefs about it. We talked about inheritance tax briefly, you might come on to it again. But now the property's in the child's name, 20%, 30%, doesn't matter. It's in their name, it's on land registry. And they want to buy a house as a first-time buyer. Sorry, mate, I see you've already got land in your name. you can't claim the privileges of a first time buyer. So you've lost that right. And then, depending on the value of the asset that you have in your name, you might actually get charged a premium, so a higher rate of stamp duty. I think it's like 3%, because you've already got property in your name, and you're buying another property.
Mm.
So people are not aware of this again. So you got to be careful of how you make the gifts. That's what higher rate stamp duty is. You're really setting up your children for a fall, rather than, you might think you're giving them the best, but actually, because you didn't get the right advice, or you weren't told because the advisor wasn't aware, then you can cause yourself a real big problem. So it's so important, when especially it comes to land and property, to get the right advice if you're thinking about making gifts.
So, just a generic piece of advice that you'd say.
Well, we're not giving advice on
Not
this show, are we?
advice. No, not advice.
We're just talking
But
for edutainment purposes.
if someone just wanted to gift a home or land to their child,
Yeah,
what would be the best way to do it?
I say first, just get the advice. Find a qualified individual, ideally someone with TEP after their name, or with experience in the area of inheritance tax planning.
Yeah.
Okay, and then ask questions. But obviously, I would say be informed when you're asking the questions, to make sure they know what they're talking about. But really, generically speaking, is this: if you're going to make gifts, because everyone's situation is different, the reason behind making a gift is different. I've got, for example, families where multiple children live in the house, like it's their main home. Well, there's things we can do about that, which is inheritance tax friendly. And so we use the word bypasses the gift with reservation of benefit rules. Yeah, there's legislation that can account for that. There may be scenarios where, unfortunately, the families are not living in the house and can't prove they live there full time. But there might be other situations where we got to, it could be maybe Sharia scenarios or whatever. Then we don't know. So everyone's situation is different. I can't give a generic blanket statement.
Yeah.
But generally speaking, I would say utilizing a vehicle like a trust tends to be a lot more beneficial for than just making an outright gift for children. Yeah. For spouses, another story, because they're exempt beneficiaries. It doesn't necessarily negate for the inheritance tax scenario, but again, everyone's situation is different, so we've got to plan for the individual. We can't just generically make statements.
Yeah.
But generally speaking, get the right advice so you can make an informed choice.
Thank you. And we're also going to cover the part of landlords.
Yes. So the second way of owning property. So a lot of people, own their main home, but there are other properties personally, not in limited companies, and so they've got a problem because the HMRC don't like investors much, unfortunately. Section 24 kind of is proof, a testament of that, and inheritance tax, unfortunately, is something that is going to be a big problem for landlords, especially if you own it in your own name. Even if you've got shares in the company, it's still a problem. But they might think, okay, let me gift the property to my children. Now it triggers another problem, because there's other taxes. Obviously, inheritance tax, when it comes to gifting to an individual, is predominantly based on a death event taking place. But there's something called capital gains tax now, and people are not aware of it. And people think capital gains tax is only when you sell a property, but capital gains tax is actually triggered on a gift. And now the rate has reduced again. I think it's £3,000. So it doesn't take a lot to trigger a gift more than £3,000, especially for land. And most properties are laden with significant gain. So you bought a house in the year 2000. It's 2024 now, right? 2000 doesn't sound like that long ago, but it's 24 years that it's had to increase in house price. Now, come on, house prices in London, just say London alone, is significant.
Yeah.
If you bought it for 100 grand, it must be worth at least 200,000. So that's £100,000 of gain, for example, that's grown in the property, latently grown in the property. So, and if you're a higher rate income tax payer, for example, your rate of capital gains tax is determined on whether you're a high rate or basic rate taxpayer, but it will be triggered immediately and it's due pretty much immediately. I think 60 days after the sale. So, or the gifts. Um, so be very, very careful of that. How you make the gift could potentially even trigger stamp duty if it's done wrong. Stamp duty land tax. You don't want that problem either.
Yeah.
So again, most people think, oh, well, I'm not selling it, so I don't have to worry about stamp duty. But capital gains tax, but it's a big deal. So you're trying to avoid inheritance tax, but you're facing the capital up to 28% in your lifetime of capital gains, and most people may not have that cash ready available to pay. So get the right advice of how to defer that potentially. And then inheritance tax is another question, because when you're using trusts and over a certain value, it can trigger inheritance tax. We'll talk about a body of trustees have their own regime during lifetime. So that could, over £325,000 will trigger a inheritance tax problem at 20%, due pretty much relatively immediately. So now we've got a 28% problem and a 20% problem. So you're paying 48% of tax for potentially for poor advice. And you're trying to save money. So we got to get the right advice and understand what's going on.
So do you have a case study for us?
Yeah, I can think of one or two. So it's a bit of a technical one. So basically, the client had their main home, sold it, had the cash, and it was a granny annex scenario. So it's a very technical case because the client built or renovated space in one of their children's homes with the money from the proceeds of the sale of the home that they sold. So because it's the same money that was used, and then they're living in the property, it's like, well, what's happened from a point of view of inheritance tax and that gift of reservation scenario? Because the wealth is still the same, whether it's cash or property, the wealth is still the same, and they're trying to reduce the assets. So I was like, well, because you live there, we can't just write it off. You live there, you're enjoying that benefit. The cash is still there, whether it's in the bank account or whether it's laid in someone else's home. You paid for it, it's there. And what's the end goal? So we had to basically work out ways of actually it's very technical because lots of things, not just inheritance tax, but all the other bits and pieces going on. But long story cut short, they had to pay market rent for basically, and then survive 7 years from the date of that indirect gift being made, in order to not be treated as a gift with reservation of benefit, so that as long as they survive that 7 years, it's not be part of their estate. If they just stayed there, it'd be part of their estate.
Yeah.
And there's just little things like that can trip people up. I mean, there's not much you can do. I mean, another scenario is another family member, well, not family member, a client had a sister living in the house and a mum living in the house, but the house was just in her name. And because the sister lived there permanently with her daughter and the mum, the option was, well, you can just gift it to the sister, at least 50%, shall we say, and it not be treated as a gift of reservation under legislation. As long as we can confirm certain criteria, then it's a genuine gift. And as long as the lion's share belong to mainly like the bills and stuff like that belong to the main owner, then there's nothing to really worry about too much. It's only when you're receiving a gift back where it's like, okay, so are you still reserving a benefit or not? So as long as the criteria can be satisfied, in that instance, because people are living in their main home full time, not just occupied, like I have access to it, but there's a common sense approach to it. Because some people, I've been approached before, oh, well, I've got my family of 3 kids and they live down the road, but I have a bedroom in my mum's house and I've got a key to get in the house. So does that deem as occupation? Well, everyone's like, well, no. This common sense approach, that's not your main home, is it?
Yeah.
it's not like you live in Scotland and you have to commute once a month down to, so you work in London, so you commute monthly, so you stay in the house. That's a whole different scenario. So that's what I'm saying. Everyone's situation is different. Not that there's a legal definition of occupation, but it's down with equity. It comes down to the facts and intention. So it's a couple of cases. I'm not going to go into too much detail because we'll be here all day. But it's just making sure people understand that there's a challenge when making a gift, especially when it comes to land. And we've got to be careful how that's been dealt with, really and truly. Yeah.
Well, thank you.
No problem.
Very, very insightful.
No, it's fine.
Appreciate it.
It's all good. It's all good. I could talk for anything about. We'll be very careful. People might fall asleep because it's a bit too technical. So, yeah, I've got to be careful.
Anyways, so that is the end of the podcast. But please, do join next week. We do this every Tuesday in the evenings. And just let us know what you'd like to see.
Definitely. And also 27th of June.
Yes, this Thursday.
So if the date, if you're watching this and it's not gone past 27th, we're having a live training all about generational wealth. Love you to join. It's free to join whilst it's live. It won't be free afterwards. So more information will be in the description or the comment box below this, or wherever you're watching it. Sign up, register. There's only 100 spaces available. Love to see you there. All about generational wealth and why it's important, how to create it, who can create it, is it exclusive or not, etc., etc. We're going to go into real detail. So join the training. It'd be fantastic to have you there.
Thank you.
Cheers. Bye-bye.